Now let's move on to procedure for division of matrimonial assets. Let's refer to Rule 56, Paragraph 1 of Divorce and Matrimonial Proceeding Rules, 1980. So, application by a petitioner or by respondent who files an answer claiming relief for an order for maintenance pending suit, a property division order, Section 76 of LRA, and a maintenance order, Section 77 of LRA. We can see the case of Susila anak perempuan Sankaran and Subramaniam anak laki Govindasamy. So in this case, the wife filed a summons in chamber seeking for ancillary relief orders against her husband. The court was of the view that where a party claiming for an ancillary relief, she or he should file a notice of application in Form 11, 12, or 13, depending on the appropriate stage of the proceedings. The mode was held to be wrong as the wife supposed to file the notice in Form 11, not file a summons in chamber. Form 11 is used when the applicant just initiates the claim for ancillary relief. Covers application for ancillary relief which have been made in petition or answer may be made subsequently by leave of court. We can refer to Rule 56, Paragraph 2. To continue, Form 12 is used to apply to court to consider the financial position of the respondent after the divorce. This is related to Rule 46, Paragraph 1 and 2. And then Form 13 is used when the applicant intends to proceed with the application of ancillary relief. It also includes situations where a petitioner has also applied for ancillary relief in her petition and intends to proceed with the application. For the place of filing, under Rule 58, when application is made under Form 11 or Form 12, the notice shall be filed A. If the cause is pending in a session court in West Malaysia or a first-class magistrate court in East Malaysia in that court, or B. If the cause is pending in the High Court in the registry in which it is proceeding, and within 4 days after the filing the notice, the applicant shall serve a copy on the respondent to the application. So this is Form 11. This is Form 12. This is Form 13. Next, my friend will continue.
Alright, so after filing Form 11 or 13, then we may refer to Rule 61, Paragraph 2 of the Divorce and Matrimonial Proceeding Rules 1980, where it states that a respondent or a petitioner that is served with a notice in Form 11 or 13 in respect of an application for ancillary relief shall within 14 days after service of the notice file an affidavit in answer to the application containing full particulars of his property and income. And if failure to do so, the court may order him to file an affidavit containing such particulars. After that, as per Rule 61, Paragraph 3, the applicant has a corresponding mandatory duty to file an affidavit in reply containing full particulars of his income and property within 14 days after service of any affidavit under Paragraph 2 or within other time as the court may fix. Alright, moving on to Rule 46, Paragraph 2, where after the applicant is served with notice in Form 12, he must file an affidavit in answer to the application containing full particulars of his property and income, and if failure to do so, the court may order him to file affidavit containing such particulars within 14 days. After that, by referring to Rule 46, Paragraph 3, the respondent has a corresponding mandatory duty to file an affidavit in reply containing full particulars of his income and property within 14 days after service of any affidavit under Paragraph 2 or within such other time as the court may fix, unless he already gave all those particulars in an affidavit filed by him or her under Rule 67, Paragraph 3. Okay, in regards to Rule 62, Paragraph 1, notice in Form 11 or Form 13 shall be supported by an affidavit by applicant stating the facts relied in support of the application. such application shall state briefly the nature of the adjustment proposed to be set aside. Rule 13 states on the application for variation order. So in this rule, an application for a variation order shall be supported by an affidavit by the applicant setting out full particulars of his property and income and the grounds on which the application is made. Rule 63, paragraph 2, the respondent to the application may, within 14 days after service of the affidavit, file an affidavit in answer. Okay, after that, according to Rule 65, it is investigation by registrar of application for ancillary relief. Rule 65 paragraph 1 states that on or after filing Form 11 or Form 13, the appointment is fixed for hearing of the application by registrar. According to Rule 65, paragraph 4, the applicant may also serve a letter of demand for further information or require the other party to furnish a list of relevant documents or allow inspection of documents. And if the respondent failed to furnish the information required under Rule 65, paragraph 4, then the applicant may apply to the registrar for direction under Rule 65, paragraph 5. Okay, continuation for Rule 65, paragraph 5. The registrar shall investigate the allegation made and may order the attendance of any person for the purpose of being examined or cross-examined and may at any stage of the proceeding order the discovery and production of any document or required further affidavit. And lastly, uh, according to Rule 767, paragraph 1, the application will be heard by a judge after the result of investigation reported by the registrar. Okay, this can be seen in the case of Liao Hui Wah, V. Philip Na Kok Sena and another, where Justice Mahadev Shankar, in deciding an application for ancillary relief made under Rule 56, paragraph 1 of the DMP rules, held in regards to the requirements of Rule 61, paragraph 2 and 65, paragraph 4 of the same rules as follows. Rule 61, paragraph 2 and 65, paragraph 4 of the rules impose upon the parties a spontaneous duty to exercise utmost good faith in making the fullest disclosure of relevant information. Whatever disclosure is by affidavit of fact, by affidavit of documents, or by affidavit of on oath. The obligation of the husband is to be full, frank, and clear in that disclosure. Any shortcomings of the husband from the requisite standard can and normally should be visited and at least by the court drawing inference against the husband on matters the subject of the shortcomings.